Welcome back to the Big Small Business Show, and we have Rui Marto in studio with us. We've had quite a full show on all the legal aspects of business. Today is a completely legal show, and we're now talking about the legal considerations around e-commerce. We get a lot of e-commerce businesses on the show, and I think they're a lot more vulnerable than they think. Is that true?
There are certainly additional obligations placed on online businesses, and so in that respect, absolutely. I think could draw to your attention that the piece of legislation which are applicable here, over and above all the other compliance issues relating to businesses, would be the Electronic Communications and Transactions Act. And certain provisions of the Consumer Protection Act, and of course POPIA, so the Protection of Personal Information Act. So those three are the three prominent ones. If we go through each one, the Electronic Communications and Transaction Act, ECTA, or ECT Act for short, really gave clarity in our law relating to the fact that electronic agreements are valid. So it does surprise me to this day that people don't realize, for example, that verbal agreements are valid, but here one step further in terms of that electronic agreements are valid. And the definition of data is not only text, but also voice. So say I sell my car to you, I could send you an email with the details. You can then send me a WhatsApp message saying, sounds great, what about this? I can then respond. You then do a voicemail to me saying, Roy, let's go ahead, I accept. Even though that's made up of now emails, messages, SMSs, all of those in terms of this legislation then would be valid forms of communication. And together, we could piece together then in terms of a contract, and the contract that would then be valid. So this was revolutionary in terms of our law, that at least it clarified that point. But it also does sound a caution for all of us, because sometimes we casually are throwing around terms, not realizing that we are potentially entering into those contracts. So sometimes I actually recommend to certain clients to include a provision in agreements to say that, that only a written contract and signed in wet ink would be a valid contract, exactly to avoid a situation where people are loosely exchanging terms and not realizing that they're entering into an agreement.
Let's move on to trading online. My requirements to protect my customers' information.
So from POPIA's respect, you now have obligations in respect of not only being able to collect that information, but how you store it and what you use it for. So you have to be able to advise now your customer that what you're going to be using his personal information for. You can only store it for the amount of time and for the purpose for which you requested the information. You can't go and share it or sell it or anything else. Obviously, POPIA came in exactly to protect those instances. Come back in terms of protections relating to the ECT Act. It puts obligations specifically in terms of retail transactions that the consumer must provide a whole set of information, including who they are, so all their business details, address, the domicilium address. But over and above that, when it comes to sale of goods, for example, it has to have a specification of what those goods are, payment terms, all the terms relating to the contract, also how you return and your returns policy and exchange policy, all of that must be recorded as per the Act. If you fail to, also if you're online, the process is that you as a consumer must be able to verify your transaction before proceeding. You must be able to amend that transaction. And if you don't have that capacity as part of your system, then the consumer is given 14 days cooling off period that they can cancel after receiving the goods. So that's a huge obligation on the part of the consumer, and one that they really should comply with.
And what constitutes online selling? Is it the fact that there is an online store? In other words, if it doesn't have to be sophisticated like a Take-A-Lot as an example, where I click on a product, it goes into my basket, I say yes, and I say purchase, and then I put my cards. Or could it be that I see something on say, I want to purchase, it sends an email to me, I mean, unsophisticated.
Yes.
And I want to buy this. Do I still have to do all that?
So as long as the transaction is through electronic means, it would fall under the Act. And that could be both the examples that you cited.
So somebody technically with I'm getting pedantic, but somebody with a website where they've got their goods and they've got inquire here, and somebody sends, I want to buy that. Now is technically an e-commerce site because a purchase took place through the site.
Correct. You'd have to comply with all those provisions. And as I said, and if you don't, then obviously there's certain protections for the consumer.
And does that include services?
It does include services. So again, if you offer services online, again, the Act still then obviously certain terms don't make any sense in relation to services, but ultimately, both in terms of this Act and the Consumer Protection Act, what it really comes down to is that you must give full disclosure to the consumer. The consumer can make an educated decision relating to whatever transaction that he's entering into. And if you fail to do so, then there are certain penalties.
Let's talk about the risks associated with digital marketing and digital advertising.
So what the Consumer Protection Act has, as well as the ECTA Act, is certain protections relating to direct marketing. So if any transaction follows direct marketing, the consumer has a cooling off period. In terms of the Consumer Protection Act, 5 days from the later of either the conclusion of the transaction or receipt of the goods, for example. So when it comes to direct marketing as part of one's digital advertising, then one has to be mindful of that. The second aspect is, of course, that the regulations relating to advertising still all apply. So you can't have any misleading advertising or anything that will induce either something which is contrary to public morality or incite violence or anything else. But also the heart of it is that you can't say that your product can or do something when it really can't, and mislead your consumer.
Roy, I could speak to you all day, and I'm sure you've enjoyed today's legal lesson by Rui Marto. Thank you for coming into studio today, and I'm sure we'll have you back again, talking about other aspects that we as entrepreneurs need to protect ourselves from and be aware of from a legal perspective. Well, that's it for today's show. Do remember, if you think it, write it down, sign it, and make it a reality.